Hi, in this presentation we will discuss about patent infringement. Basically three types of patent infringement: direct infringement, contributory infringement, and induced infringement. Under direct infringement, it can be again of two types: literal infringement, and second is infringement under doctrine of equivalence. Under contributory infringement, when somebody is contributing to the infringement. Suppose patent on use of X in food. Person manufacturing X is contributory infringer if X has no other use. Induced infringement, when somebody knowingly or unknowingly encouraging others to infringe a patent, that will be induced infringement. So we'll discuss all these types of patent infringement in detail in coming slides. Direct infringement, it is most obvious type of infringement when someone actually practice claim of a patent without patent owner's permission. That will be a direct infringement. Direct infringement is by person who is actually making or using or selling the claimed invention. One might be making, using, or selling a product which had never been made before. However, he still be directly infringing others' patent because patent claims were broadly worded. The patent may not be directly claiming the patent, but the patent claims are so broad that it's somehow claiming that product. So when somebody actually practice the claim of a patent without the permission and he is using, making, or selling the claimed invention without permission, that will be a direct infringement. Contributory infringement, when someone manufactures a product which is specially designed to be used by others in a infringing manner. Let us understand with an example. Suppose patent is claiming use of ingredient X in food and it is not having any other claim. It is not claimed as a product or it is not claimed as a manufacturer or anything else. It is claiming only use of X in food. Now another person who is making a food with X will be directly infringing the patent. But another person who manufactures X might be guilty of contributory infringement when X has no other substantial non-infringing use, but only use in the food which is claimed in a patent. But if there is another use of X other than the infringing use, then one has a good argument that it is not contributory infringement. Suppose X is having two uses, use in food and use in medicine. Now use of X in food is patented, but use of X in medicine is not patented. Now if the infringer he may argue that I am using X in medicine, not in food. So that will be a good argument to avoid infringement. Induced infringement, when one knowingly or unknowingly encourages another person to do something which infringes another's patent. For example, if there is an existing method of use patent on gabapentin for treatment of neuropathic pain. So gabapentin is having indication patent for treatment of neuropathic pain. The other patent like product patent, formulation patent, or API patent are either expired or they are not being infringed. So only relevant patent is method of use or indication patent for treating neuropathic pain. Now, for example, gabapentin, a generic company, has got approval for use of gabapentin in treatment of epilepsy, which is not patented. So, generic was approved for treatment of epilepsy, which is not patented indication. Now suppose if generic company promotes gabapentin to doctors to prescribe gabapentin for treating neuropathic pain, which is patented indication. In that case, generic company may be guilty of induced infringement because here generic company is inducing the doctors to prescribe gabapentin for treating neuropathic pain, which is patented indication. So in that case, the generic company will be or may be guilty of induced infringement. Now, coming to literal infringement, which is a part of direct infringement, when properly construed claims read on accused product or process, that will be literal infringement. Or when accused product or process fall within the scope of claim of a patent, that will also be literal infringement. When every limitation of the construed claim is present in the accused product, that will be literal infringement. When there is a no literal infringement, then doctrine of equivalence or DOE and prosecution history estoppels are considered for finding out infringement. So we'll discuss about these in detail in coming slides. To find out literal infringement, you have to construe the claim. You have to find out the meaning of the claim. You have to interpret the claims. So some important points while interpreting the claims or when construing the claims. Claim construction is exclusively allocated to judges in the court in order to promote uniformity of the claim construction. So whenever there is an issue of claim construction or patent infringement, the case goes to the court. Now judge in the court will decide about the infringement and construction of the claims. Although the prosecution history is primary source of claim interpretation, it cannot be used to enlarge or diminish or vary the limitation in a claim. As I said in some previous presentation, the prosecution history file is a file with patent office which keeps all the record of communication between examiner and the patentee. When examiner raise certain objection for patentability, then the patentee will reply to those objections, and he may have disclaimed something in order to avoid the objection. He may have narrowed down the scope of the claim in order to avoid the objection of examiner. So all these communication are with the patent office in a file that is called prosecution history file or file wrapper. So in claim construction, the file history or prosecution history estoppel or file wrapper is always considered in order to construe the claim or to interpret the claim or to find out the meaning of the claims. Consideration of extrinsic evidence like testimony, expert testimony, or dictionary meaning is discretionary with the court as aid in claim construction. Court may take their help or may not take. It is discretionary to the courts. But courts cannot be compelled to receive expert or extrinsic evidence. Such evidence may not be used for purpose of varying or contradicting the language of the claim. You cannot change the language of the claim with such expert or extrinsic evidence. Now coming to infringement by doctrine of equivalence. If there is a no literal infringement, then you have to find out whether there is a infringement by doctrine of equivalence. Doctrine of equivalence catches infringer practicing just the obvious version of invention. which is not literally infringing the claim, but device is not different or distinct from the claimed invention. The infringer has just made minor changes in his product in order to come out of the claim. So in order to catch such infringer, doctrine of equivalence is applied. Doctrine of equivalence extends the scope of patent claim beyond their literal meaning or literal boundaries. It expands the scope of the claim. Any analysis of infringement under doctrine of equivalence necessarily deals with subject matter that is beyond or ignored by or not included in the literal meaning of the or scope of the claim. So, doctrine of equivalence expands the meaning of the claim beyond literal meaning in order to catch the infringer who has made minor changes in the product in order to come out of the infringement. Doctrine of equivalent prevents infringer from stealing the benefit of the invention. Doctrine of equivalence is an equitable doctrine designed to relieve inventor from a cemented straitjacket or from a fixed position wherein insubstantial changes are made by infringer in his accused product in order to avoid literal infringement of patent. By making minor changes in this product in order to come out of the patent infringement, he has done minor changes. So to catch such infringer, doctrine of equivalence is applied. Doctrine of equivalent prevents practice of fraud on patent. Equivalency is not defeated by using additional step to achieve what patent achieves in one step. So as I said earlier, by doing some minor changes, suppose patent is claiming manufacture of a product in just one step. Now in order to come out of the scope of the patent claim, now the infringer is using two steps but ultimately producing the same. So such kind of infringer are catched by doctrine of equivalence analysis. Under doctrine of equivalence, an accused product, process, or device may infringe a claim if it performs substantially the same function in substantially the same way and achieving substantially the same result as claimed invention. So this is the test for catching infringer under doctrine of equivalence. You have to find out whether the infringer product is having the same function or and it is working in the same way and achieving the same result as claimed invention. And if it is, then you can catch him under doctrine of equivalence. The doctrine of equivalence will apply in that case. Doctrine of equivalence must be applied to individual element of claim and not to the invention as a whole. Equivalence should be found for every limitation of the claim somewhere in the accused device. Doctrine of equivalence will not extend to cover the accused device which is there in the prior art, or if prosecution history estoppel prohibits that. The equivalent which is already there in the prior art, and if the infringer is practicing that equivalent which is already disclosed in the prior art, then doctrine equivalent will not apply. Similarly, if patentee has disclaimed a equivalent of his invention during prosecution, so you need to find out in prosecution history if he has disclaimed some equivalent during prosecution. So if he has disclaimed something during prosecution, then prosecution history estoppel will apply and doctrine of equivalence will not be applicable in that case. So that is called PHE, prosecution history estoppel. Means prosecution history will stop him from claiming infringement of that equivalent which patentee has already disclaimed during the prosecution history or during prosecution of the patent which is available in the prosecution history. So by seeing the prosecution history file, one can find out whether patentee has disclaimed some equivalent during prosecution, and if the infringer is practicing that disclaimed equivalent, then doctrine of equivalence will not apply. The US Supreme Court has said that equivalents are not limited to equivalents disclosed in patent itself. Equivalents outside the patent will also be covered by doctrine of equivalence. Equivalency determination is made at the time of infringement and not at the time of patent issue. Now, steps to determine infringement under doctrine of equivalence. First, construe or interpret the claims to determine the meaning of the claim. Then, second step, determine whether literal infringement of the construed claim. If no literal infringement, then determine if accused device, process, or composition is equivalent to that of claimed invention. So first construe the claim, then find out the literal infringement. If no literal infringement, then find out if there is a infringement by equivalence or by doctrine of equivalence. If there is a infringement by equivalent, the patentee is just practicing the equivalent invention, which is substantially the same with some variation. If yes, then also determine if extension of literal language of claim is prohibited by prior art or prosecution history estoppel. As I explained in the previous slide, if prior art has already disclosed some equivalent, then doctrine equivalent will not apply. If the prosecution history also has some disclaimed equivalent, then also doctrine equivalent will not apply. Now, slide on prosecution history estoppel. Whenever whatever has been disclaimed by applicant during prosecution will be in public domain, and it cannot be reclaimed later during litigation, and it will give rise to estoppel, or it will stop the patentee to apply whatever has been disclaimed during prosecution. It cannot reclaim it again during litigation for that subject matter. When amendments made to claim or argument made to distinguish the feature of invention from prior art, then also prosecution history estoppel or PHE applies. PHE or prosecution history estoppel may apply even when amendments made for reason other than the patentability. Unnecessary arguments or amendments may create prosecution history estoppel. So you have to be careful not to do any unnecessary argument or not to do any unnecessary amendment. So not to argue with the examiner unnecessarily during prosecution, that may create prosecution history estoppel. And prosecution history estoppel may prevent infringement under doctrine of equivalence. An effective method of controlling prosecution damage during prosecution is to argue the language of the claim whenever possible without providing applicants personal interpretation of the scope of the claim in response to arguments. Now coming to willful infringement. When somebody infringes a patent willfully, intentionally, knowing that he is infringing, then that will be called willful infringement. And if somebody is found with willful infringement, then 3 times damages will be awarded to patent it as compared to normal infringement. So one has to be careful. Willful infringement is very costly. Issue of willful infringement is also accompanied by intent, belief, and credibility. So court will find out the intention of the infringer. Party without knowledge of patent cannot be held liable for willful infringement, but will be liable for normal infringement, not willful infringement. Rejection of license offer without even consulting in-house attorney is a factor that tends toward willful infringement. So while finding out Willful infringement court will see all these factors. Other factors like failure of patentee to investigate for infringement after sending a warning letter by patentee. Once the warning letter is sent by patentee, the infringer is not investigating the infringement. So that factor will be considered by court. To serve as exculpatory legal advice, opinion of attorney is viewed objectively by court to determine whether it was obtained timely, whether advice was obtained timely by infringer, whether counsel analyzed the relevant facts, explained the concluding light of applicable law, and whether opinion warranted a reasonable degree of certainty that infringer had legal right to conduct infringing activity. Maybe infringer believes that the patent is invalid or not infringed based on the legal advice. Now coming to frivolous infringement suit. A frivolous infringement suit is one that patentee knows or in a reasonable investigation should have known that infringement suit was baseless. So sometimes the company they also file for frivolous infringement suits. When patentee files a baseless infringement case through studied ignorance, which is substantially more than the simple negligence, in that case, there must be proof of actual wrong intent or gross negligence. So, the court will find out the intention of the patentee, whether he has filed the frivolous case or not. Will find out the intent and gross negligence of the patentee. And in one case, accused infringer sought attorney fee for failure of patentee to investigate infringement before sending a letter. The patentee has sent the infringement letter without properly investigating whether there is a infringement or not. In that case, the court has awarded the attorney fee to infringer. So that's all in this presentation. Thank you very much.